have seized without complying with due process of law, first treating the claimants inhumanly and degrading. They and their numerous dependents, they have been in shock and undergoing untold hardship as a result of the unlawful action and inaction of the defendants. Let me briefly state the case of the first defendant and the counterclaim. The first defendant stated that the claimants were employed by the first defendant and duly paid their entitlements until disengagement, that in line with statutory requirement, the staff were registered for contributory pension and same was duly contributed on their behalf. They had no reason to retrieve any staff employment letter and never did. It never detained any documents of the claimants. Though the first defendant duly contributed on their behalf, it is not in the position to process and pay the pensions to the claimants. The claimants, along with all their colleagues recruited for the first defendant projects in Bayelsa, were disengaged sometimes in March 2020 via the notice, which the claimants and others refused to either make themselves available to collect or receive, but failed to endorse and return. Now, many of the staff refused and or neglected to endorse the letter of disengagement. They were still paid in March 2020 in line with the notice of disengagement. The arrears of salary for April 2020 and beyond fraudulently claimed herein are found. The claimants were given the best of treatment when in employment of the first dependent, paid a very high salary of 100,000 naira only, which at the time was way more than some senior civil servants earned, and were given some paramilitary training to make them recruitable by any paramilitary body in the world. For as many that made themselves available and or contacted the first defendant representative thereafter, the first defendant provided the necessary documentation for them to access their pension. The first defendant further stated that sometimes in 2015, its affiliate company, Startup Point Integrated Services Limited, was contracted by the federal government of Nigeria under the Nigerian Energy Security Command, supervised by the National Security Advisor, to protect onshore petroleum pipelines in Bayelsa State. The project was a collaboration between the National Security Advisor, National Security and Civil Defense Group, Startup Point Integrated Service Limited, and the first defendant. To effectively carry out its activities, the first defendant deemed it necessary to engage members of the communities where the pipelines were located. The relevant community chiefs or leaders were contacted and briefed on the project and the mandate of the federal government of Nigeria. It was agreed that the communities should nominate able-bodied members of their communities to be recruited as guards to monitor the pipelines in their various locales. Almost all nominees from the communities had no valid means of identification, birth certificates, school certificates, a specific address, bank accounts, or the required guarantors. The chiefs and opinion leaders then convinced the first defendant to recruit those who passed the physical training, and the chiefs who nominated them will act or serve as their referees or guarantors. The first defendant never advertised any vacancy, nor did the company apply for a job in the first defendant's company, nor did the claimants apply for a job in the first claimant's company. The communities were largely happy with the arrangement and are really pleased to get many of their uneducated and unemployed indigents gainfully employed to protect pipelines, which also translated to a safe environment for them to farm and fish. All the nominees from the various communities were put through different levels of training in batches, and those selected were given their employment letters, either directly or through their chiefs or leaders, depending on the batch and where they were posted to serve. Though most had no proper documentation, the first defendant enrolled them and produced company identification cards with them, with which bank accounts were opened, as most of them had never opened bank accounts for themselves. And in order to avoid any community issues and for proper documentation and accountability, the first defendant was also constrained to bring bank officials to the training ground and ensure the accounts were open for them to receive their salaries. That open recruitment, each guard was given uniform trousers 2 pairs, uniform shirt 2 pieces, green shirts, dry fit 2 pieces, black hats 2 pieces, black shoe 2 pairs, black belts 2 pieces, t-shirts 4 pieces, pack bag 1 piece, green water bottle 1 piece, flashlights 1 piece, first aid kits 1 set, GPS 1 piece, and binoculars 1 piece. The project was short-lived, and the federal government stopped funding it immediately after the change of government in May 2015. The first defendant managed the situation with assurances that the new government of the day We resumed funding, but it never materialized. With the uncertainty and lack of funding from the federal government of Nigeria, the first defendant staff became redundant from March 2017 because the project was for 2 years in the first instance, from February 2015 to March 2017. The first defendant had to ask all its staff, including the claimants, to down tools and stay home until further development, since there was no funding from the federal government of Nigeria. While few key staff worked until September 2017, most of them stopped rendering any service and all went outfield to guard pipelines since March 2017, when the initial period of engagement with the federal government expired. Between the said September 2017 and March 2020, all the staff, including the claimants, were paid their full salaries, though they rendered no service within the period of 18 to 24 months, respectively. Now, sometimes in 2020, the first defendant decided to cut its losses, having expended so much on wages without any service rendered, and all hopes of getting the new government to fund the project failed. From January 2020, it started disengaging its staff, but realized that many were refusing to come forth when called upon by the first defendant representatives. It became clear that the news had gone round that when invited, they would be served with a disengagement letter, and the staff did not want to stop enjoying the free monthly payment they had been enjoying for almost 2 years. The last set of disengagement letters, including those of the claimants, were ready for service on the 5th day of March 2020. And when called upon, the claimants failed to report to Yenegoa and collect their engagement letters. Text messages were sent to them, and the chief's leaders were notified that all staff would receive their last payment at the end of March. Most of each staff heeded the call, made themselves available to receive their severance documents, and have since accessed their pension from the first defendant. Only the claimants and their ilk are left. All they seek to profit their deliberate and willful scheme by refusing to accept their disengagement letters and process their pensions. Its staff, including the claimants, were expected to return all company properties in their custody. At all times leading to this suit, the claimants acted fraudulently and now seek to use the courts to benefit from their own fraud. Let me briefly state the defense of the third defendant. The third defendant stated that the third defendant is neither a director, nor a shareholder, nor an employee of the first defendant. Thus, the third defendant cannot be the hand and mind of the first defendant in respect of any dealing between the first defendant and the claimants or any other party. The third defendant does not know whether the claimants were employed by the first defendant and were being paid monthly salaries, and deductions were made to the second defendant. The third defendant, not being a director and employee of the first defendant, never received any salary or allowance from the first defendant, and therefore cannot hold himself out as a coordinator to the first defendant, and cannot have the first defendant's official transaction documents. Counsel for the claimants nominated 4 issues for the determination of this suit, to wit, whether or not the claimant's contract of employment with the first defendant were terminated in line with the due process of the law. And secondly, whether or not payment of damages in favor of the claimant is not an automatic result of termination of claimant's contract of employment without prior written notice or payment of salary in lieu of notice. Thirdly, whether or not the contributory retirement savings or pension scheme in the custody or administration of the second defendant, sourced from the deduction from the claimant's monthly salaries and monthly contribution from the first defendant, are not withdrawable by and payable to the claimants without further ado. And fourthly, whether or not the first defendant's counterclaim is grantable by this honorable court. Counsel for the first defendant nominated 2 issues for the determination of this suit, to which whether the claimants are entitled to all the reliefs claimed against the first defendants, and secondly, whether the first defendant is entitled to his counterclaim. Counsel for the second defendant nominated a loan issue for the determination of this suit, to it whether the claimants are entitled to a total withdrawal of funds from their pension fund account. And counsel for the third defendant nominated 2 issues for the determination of this suit, to it whether in view of the totality of evidence before this court, the claimants are entitled to any relief against the third defendant. And secondly, whether any person who is not a party to a contract can be liable for any breach therein. Having carefully studied the pleadings and the evidence led by parties in respect of their respective claims, the issues for determination of this suit are as follows. Firstly, whether the claimants have proved their case on preponderance of evidence to entitle them to the relief fund. And secondly, whether the first defendant counterclaimant has proved its counterclaim on preponderance of evidence to warrant the grant of the counterclaim reliefs. So I will skip your legal arguments and I will go to the decision section.
As the court pleases.
Because of time. So I will go to the decision section now. Court's decision.
As the court pleases.
I have carefully analyzed all the process filed by parties and also the evidence adduced by both parties. On issue 1, first and foremost, it is essential to recap the established principle of law on the burden of proof, and it is based on which the court can resolve the claim of the claimants. The burden of proof is on the party who asserts that a fact to prove it on the preponderance of evidence in civil cases. Therefore, once a claimant has proved his claim on the balance of probabilities and preponderance of evidence, the burden shifts to the defendant to prove any facts he relies on to establish his case. See the cases of Otuama against Akpeime, Daudu against NNPC, Agbi against Ogbe, Brahma against Abasi. In essence, the claimants have a burden to prove their claims against the defendants. And until such a burden is discharged, no reasonable court will ever call upon a defendant to disprove a claim that has not been proved by the claimants. The claimants pleaded that the first defendant employed them. The first defendant admitted that the first defendant employed the claimants. In legal proceedings, a party's admission serves as the most compelling evidence, relieving the opposing party from the burden of proof regarding the admitted facts. In civil cases, such admissions are considered evidence against the admitting party, unless valid explanations are provided to the court. Therefore, once a party acknowledges a fact in their legal pleadings, they are bound by this admission and they cannot later dispute it. Consequently, a court is permitted to render a judgment based on these relevant admissions. See the cases of Hussein against Daud, Salawu against Yusuf, or citations provided. More importantly, there are 3 categories of employment contracts. We have the pure master and servant relationship. And we have employments where servants hold their offices at the pleasure of their employer or masters. And we have employment with a statutory level. In the master and servant relationship, the master has an unfettered right to terminate the employment. However, he must comply with the procedure stipulated in the contract. But in a contract with statutory level, the employment is protected by the statute. In the event of termination of employment with statutory level, strict adherence must be had to the statute creating the employment. See the case of Longi against Space Bank Nigeria PLC, Mobile Producing Nigeria Unlimited against Johnson, and Ofori Share against Nigerian Gas Company Limited, all citations provided. Besides, it is very crucial and worthwhile to determine the nature of employment between the claimants and the defendants, with whosoever is the employer of the claimants. An employment is said to have statutory labor when the appointment and termination or discipline of an employee is governed by statutory provisions. In other words, where the contract of service is governed by provision of statute, or where the conditions of service are contained in regulation derived from statutory provision, they invest the employee with a legal status higher than the ordinary one of master and servant. And such a contract of employment has statutory labor. See the case of Kwara State Judicial Service Commission against Olani. It is axiomatic to note from the onset, based on the pleadings of both sides, that the first defendant from all indication is not a creation of statute, but is just a corporate body incorporated under the Companies and Allied Matters Act. Employment in a body or company does not have a statutory label, merely because the government has shares in it. It does not matter that the government has majority shares in that company or that it is a statutory corporation. An employment is said to have statutory label only when the appointment has been protected by statute. Therefore, except employment governed by statute wherein the procedure for employment and discipline of an employee has spelled out, any other employment outside the statute is governed by the terms under which the parties agreed to be master and servant. See the case of Udo against CSNC. In this instant case, the first defendant is an incorporated body. Neither was there any indication before this court that the first defendant was created by a statute. Hence, the employment of the claimants with the first defendant is purely a master-servant relationship that is guarded and guided by the terms and conditions contained in the contract of employment, and I so hold.
Has the court
Having carefully read through the pleadings and the gamut of evidence before me, the claim of the claimant is neither here nor there. The claimants pleaded and laid evidence to state that the first and third defendants are owing them payment of arrears of salaries of April and May 2020 salaries and subsequent month till the process of the law is complied with as regard termination of contract of employment. Their contract of employment with the first defendant is valid and subsisting until otherwise, as they were never accused of any gross misconduct and never faced an investigative or disciplinary panel where they are given a fair hearing and found guilty and recommended for summary dismissal. But the snag in the case of the claimants is that while the claimants claim that their employment with the first and third defendants still subsists until the due process of law is complied with regard to termination of contracts of employment. But the claimants did not tender their letter of employment to ascertain the terms and conditions of their employment with the first and the third defendants. The pleading of the claimants as regard to the alleged law that the first defendant failed to comply with is cloudy, thereby making the claim of the claimants on termination of employment of the claimant a wild goose chase. A court is not allowed to make findings on documents that have not been laid in evidence before it, because a court cannot speculate. See the case of Alkali against Lagos State Government. In the case of Beore against Delta State Company Limited, reported in 2023, 14 NWLR Part 1904 at page 203, the Supreme Court held, and I quote, "It said straight law that when an employee complains that his employment has been wrongfully terminated, he has the onus, first, to place before the court the terms of the contract of employment, and second, to prove in what manner the said terms were breached by the employer. It is not in principle for the employer who is a defendant to an action brought by the employee to prove any one of these," unquote. Also, in the case of Idoniboyobu against NNPC, the Supreme Court held, and I quote, "A servant who complains that his employment has been brought to an end must found his claim on the contract of service and show in what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. It is not the duty of the employer as dependent to prove that the termination of his employment was wrong," unquote. It is therefore the finding of this court that the claimants failed to place before this court the terms and conditions of their employment, which the first defendant failed to comply with, and failure of the claimants to prove that their employment is unlawfully terminated. The court will not call on the first defendant to prove the said alleged unlawful termination of employment of the claimants, and I so hold.
Has the court please?
On the claim of the claimants for their unpaid salary for April and May 2020, the claimants pleaded and laid evidence to state that the first and the third defendants owed them payments of arrears of salary for April and May 2020 salaries, though the pleading of the claimant is silent on when their employment relationship with the first defendant ceased. However, the first defendant in paragraph 10A of its amended statement of defense and evidence of Chief of DW1 at paragraph 12A state that the claimants were disengaged in March 2020 via the notice which the claimants and others refused to either make themselves available to collect or receive. DW3 maintained under cross-examination that in January 2020, the first defendant informed all staff who were on the ground that the employment of all staff will be terminated in March 2020. It has been established by evidence of DW3 that the employment relationship of the claimants with the first defendant was terminated in March 2020. Thus, if the claimant ceased to be the employees of the first defendant by March 2020, I do not see any justification for claiming a salary for April and May 2020. The claimants failed to prove that they are entitled to salary for April and May 2020, and I so hold.
As the court pleases.
On the claim of the first and the third defendants, have documents needed to access and withdraw the claimant's pension savings with the second defendant. The claimants pleaded and laid evidence to state that their contributory retirement savings and the first defendant percentage of contribution to the scheme are in the trust custody of the second defendant, are relevant documents with which to access and withdraw the funds standing in their own favor are being detained by the first and third defendants, and that the defendant should cause the immediate payment of all entitlements due to the claimants. The first defendant pleaded and led evidence to state that the staff of the first defendant who made themselves available and or contacted the first defendant's representative thereafter first defendant provided the necessary documentation for them to access their pension. Considering the pleading of the first defendant admitted that the first defendant is in custody of the documents needed to access the pension contribution of the claimants. First defendant has terminated the employment of the claimants. First defendant cannot continue to retain the pension documents of the claimants, and I so hold. Lest I forget, the claimant stated that the third defendant was holding himself out as a coordinator, discharging assigned tasks, and had been receiving monthly salaries from the first defendant. The first defendant pleaded that the third defendant was never a director or the controlling mind of the first defendant. It is glaring from evidence before this court that the first defendant is the employer of the claimants, who hired and fired the claimants. Joining the third defendant to this suit is unnecessary, as the third defendant does not have any interest in the first defendant. Lastly, on the withdrawal from the pension contribution of the claimants, the second defendant submitted that the claimants are alleging that upon termination of employment by the first defendant, the claimants are entitled to immediate withdrawal of the totality of their retirement savings account. The claimants have no such right. At best, the claimants on the satisfaction of the National Pension Commission can receive 25% of their contributory pension from the date of cessation of employment if it is satisfied that they have been unemployed for 4 months after the cessation, cited Section 7 and 16 of the Pension Reform Act. The claimants cannot claim the totality of the savings, and they need to show that the National Pension Commission approves of that withdrawal. The absence of this shows that the material facts necessary to claim a withdrawal from their savings account have not been accrued. The pension contribution and withdrawal from the pension savings of the claimants are regulated by the provisions of the Pension Reform Act. And Section 16 of the Pension Reform Act provides that an employee who is less than 50 years old shall not have access to the withdrawal of their pension contribution. In this instance, the claimants failed to plead their age for the court to determine whether the claimant can completely withdraw their pension contribution in the custody of the second defendant. Thus, the claimants cannot access their pension contribution in custody of the second defendant without complying with the provision of Section 16 of the Pension Reform Act. On the whole, SC1 is partly resolved in favor of the claimants. I therefore ordered as follows. A declaration is made that the claimants are entitled to access and withdraw the totality of their contributory retirement pension with the monthly percentage the employer was required by law to contribute from the second defendant who has been in custody of same, subject to the compliance with the provision of Section 16 of the Pension Reform Act. An order is hereby made directing the first defendant to immediately release all relevant documents needed to access and withdraw the claimant's pension savings with Trust Fund Pension Limited in the first defendant position. An order of this court is made directing the second defendant who has been in custody of the monthly contributory retirement savings of the claimants plus the monthly percentage, that is the employer percentage, is required to contribute immediately, pay the claimants the totality of their contributory retirement savings into their bank accounts on presentation of certificate of registration, subject to the compliance with Section 16 of the Pension Reform Act. On the counterclaim of the first defendant, a counterclaim is a separate action. The effect of failure to file a defense to a counterclaim is the same as that of the defendant in the normal action commenced by writ of summons, who have been served with a statement of claim, fails to file a statement of defense in challenge of the statement of claim. Even where a statement of defense has been filed and no evidence is laid on it, the defendant is deemed in law to have abandoned his defense and admitted as true the averments of the statement of claim. And the onus now is placed on the claimant or plaintiff to prove his case becomes minimal. See the case of Olale against Wema Bank Limited. The first defendant counterclaimant accused the claimants of fraud, which the first defendant counterclaimant must prove beyond reasonable doubt. Fraud implies a willful act on the part of anyone, whereby another person is sought to be deprived of illegal or inequitable means of what he is entitled to. Fraud for purpose of civil law includes acts, omission, and concealment by which an undue and unconscious advantage is taken of another person. See the case of Kwara Poly MSC Limited against Abdullahi, reported in 2024, 5 NWLR Part 1934 at page 483. Fraud is an intentional perversion of truth to induce another in reliance upon it to part with some valuable thing belonging to him or surrender a legal right. It is something dishonest and morally wrong. See the case of Utupo against Job. The first defendant counterclaim pleaded that upon the recruitment of the claimants in February 2015, each guard or claimant was given uniform, black hats, green t-shirts, pairs of belts, shoes, backpack, water bottle, flashlights, first aid kits, GPS, and binoculars. The claimants were disengaged in March 2020, and the claimants were expected to return all company properties in their custody. However, the claimants pleaded that the listed gears and wear were given freely. A crucible study of the pleading and evidence of the first defendant. There is no evidence before this court where the first defendant counterclaimant demanded that the claimant should return all these properties given to them, which were given to the claimants by the first defendant counterclaimant upon the recruitment of the claimants. I do not think the failure of the claimants to return the wares and gears given to the claimants by the first defendant counterclaimant constitute frauds, as the first defendant counterclaimant did not demand the return of the items given to the claimants upon their recruitment. Therefore, the first defendant counterclaimant fails to prove its counterclaim and is therefore dismissed accordingly. In all, reliefs 4, 6, and 7 succeed and are granted accordingly, while all other reliefs are dismissed for lack of proof. The counterclaim is dismissed for lack of proof. All terms of this judgment are to be complied with within 30 days from today, without prejudice to the right of appeal by both parties, and judgment is hereby entered accordingly.
As the court pleases. My lord, we are most grateful for the well-considered and eruditely delivered judgment. We appreciate your lordship for the industry.
Thank you. Yes, second case.
Yeah, I'm most grateful, sir.
Yes.
Case number 2. NICS 06 between Jasper F. Abode and Bayelsa State Government and 2 months.
Eva. Yes, representation. Yes. Singer.
My lord.
Yes, second matter. Just
My lord, I am. Yes, sir. My lord, Christopher.
Claimant counsel not in court.
I'm in court, my lord.
Claimant's counsel, yes.
I'm in court, my lord. Christopher, CIPT. Christopher, CIPT for the claimants. We are most grateful.
Yes, defendant.
With the greatest respect, my lord.
Yes.
Z Singer.
Yes.
Assistant Chief State Counsel, Ministry of Justice, for the defendant.
For all the defendants, Singer.
Yes, my lord, for all the defendants on record.
Okay. Yes, this is judgment of the court. The claimant commenced this suit by way of complaint filed on the 17th day of February 2022, pursuant to Order 302 of the rules of this court, whereas the claimant claims against the defendants the following reliefs: a declaration that the claimant is entitled to earn and did earn the sum of 22,870,213 naira as salaries and allowances as 4-year tenure chairman of Bayelsa State Environmental Sanitation Authority Board from 2011 to 2015 from the defendants. A declaration that the termination of the appointment of the claimant as chairman of Bayelsa State Environmental Sanitation Authority without payment of the sum of 22,870,213 naira as earned salaries and allowances as 4-year tenured member and chairman of Bayelsa State Environmental Sanitation Authority Board from 2011 to 2015 by the defendants is illegal, unlawful, and exploitative. An order of this honorable court compelling and directing the defendants to jointly and severally to forthwith pay the sum of 22,870,213 naira as earned salaries and allowances as a 4-year tenured member and chairman of the Bayelsa State Environmental Sanitation Authority Board from 2011 to 2015 to the claimant. An order of this honorable court awarding the sum of 10 million naira only as general damages against the defendants jointly and severally. And an order of this court awarding the 10% post-judgment interest in favor of the claimant against the defendants until the judgment is fully complied with. The claimant predicated his claim on the statement of fact and witness statement on oath filed on the 17th day of February 2022, and reply and further witness statement on oath filed on the 14th day of June 2022. The defendants based their defense on the joint statement of defense and a witness deposition on oath filed on the 11th day of May 2022. At the plenary hearing on the 14th day of June 2022, the claimant called his first witness. The claimant, who testified for himself herein after referred to as CW1, identified his deposition made on oath on 17th day of February 2022, and further witness statement on oath filed on the 14th day of June 2022, and adopted same as his evidence in support of his case. CW1 thereafter tender exhibit CW001 to CW004. On the 12th day of December 2022, the defendants opened their defense. Raphael John, herein referred to as DW1, testified for the defendants. DW1 identified his statement on oath filed on the 11th day of May 2022 and adopted same as his evidence in support of the defense of the defendants. DW1 thereafter tendered exhibits DW001 and DW002. After the close of hearing of this suit, on the 5th day of May 2025, the matter came up for adoption of final written address filed by counsel. Learned counsel for the defendant, Z. Singer, identified his final written address filed on the 8th day of February 2023 and adopted same as his legal submission in the aid of the case of the defendants and urged this court to dismiss the suit. Counsel for the claimant, A. Asiafiti, identified his Christopher Asiapiti identified his final written address filed on the 29th day of November 2023 and adopted the same as his legal submission in the aid of the case of the claimant while urging this court to grant the claim of the claimant. Let me briefly state the case of the claimant in brief. The premise of the claim of the claimant is that the claimant is a lecturer and a professor in the Department of Biological Sciences, Faculty of Science with the Niger Delta University, Wilberforce Island, Bayelsa. The claimant was appointed as chairman of Bayelsa State Environmental Sanitation Authority Board in 2011 by the first defendant. The claimant was given an appointment letter dated 9th day of February 2012 by the first defendant, but which was made to take effect on the 9th day of February 2011. The first defendant inaugurated the claimant as chairman together with other members of the board of the third defendant for a 4-year tenure, for a 4 years tenure term, following which the claimant worked with other members of the board until the emergence of new government under the leadership of Honorable Siriake Dixon in 2012. And the said Honorable Siriake Dixon-led government dissolved the board without any justifiable cause. The claimant stated that the claimant was removed as a member, chairman of the board in 2012 by the first defendant without being paid any salary and other entitlement or earned allowances. As a chairman of the Bayelsa State Environmental Sanitation Authority Board, the claimant is entitled to a basic salary of 427,350 naira only, and an allowance of 192,378 naira 13 kobo respectively, amounting to a total of 619,728 naira 13 kobo as monthly earned from 2011 to 2015. The claimant is also entitled to severance, the first 28 days hotel and transport allowance monthly, for which the claimant was not paid and denied same by the defendants. The claimant further stated that the claimant is entitled to earn and did earn the sum of 22,870,213 naira as basic salary and allowance for 4-year tenured member and chairman of Bayelsa State Environmental Sanitation Authority Board from 2011 to 2015. The first defendant brought to an end the appointment of the claimant as a 4-year tenured member and chairman of Bayelsa State Environmental Sanitation Authority Board and denied the claimant of all salaries and allowances which the claimant is entitled and earned as member and chairman of the said board from 2011 to 2015. That by the civil service rules, every tenured appointment in Bayelsa State, including appointment into the Bayelsa State Environmental Sanitation Authority Board as member or chairman, is entitled to salary, severance, and other allowances, and more so where such appointment is untimely brought to an end, as in the instant case. That upon the abrupt termination of the claimant's appointment as a member and chairman of the third defendant, the claimant and other members of the board wrote to the first defendant through her secretary requesting the payment of the said earned salaries and allowance, but to no avail. The first defendant through her secretary had received the letter, but the defendants did nothing about the request and continued to promise to pay or handle the matter until the Honorable Siraki Dixon-led government came to an end sometimes in 2019. He said he earned all the salaries and allowances as a member and chairman of the board from 2011 to 2015, as indicated in his letter of appointment. And the claimant did nothing unlawful to warrant his removal as chairman and member of the board before the expiration of his tenure. That the defendant did remove him as a member and chairman of the board and denied the claimant of all his entitlement and allowances. As a member and chairman of the board from 2011 to 2015, the claimant is entitled to be paid and given the sum of 22,870,213 naira under his appointment for 4 years, and his removal by the defendant and consequent denial of the earned salaries and allowances caused the claimant untold hardship and consequently reduced the self-emptying personality of the claimant, exposed the claimant to wanton ridicule, and the defendant did not treat him with respect. His appointment as a member and chairman of the board prevented the claimant from participating in the technical report writing session for the Seni Appraisal Well Environmental Impact Assessment Report at the instance of the Amakro Nigeria Limited in conjunction with Shell Petroleum Development Company Nigeria Limited from the 12 to 26 days of February 2012. And his appointment as a member and chairman of the board also further prevented the claimant from participating in the technical report writing session for the Odeama Creek South Non-Exploration Well and Odema Well 5 Sidetrack Environmental Impact Assessment Report at the instance of the Amakro Nigeria Limited in conjunction with Shell Petroleum Development Limited from 4th March 2012. Following his appointment as a member and chairman of the third defendant, the claimant could not participate in the said technical report writing sessions because his appointment as a member and chairman of the Bayelsa State Environmental Sanitation Board, which coincided with claimant's invitation for the said technical report writing session, was consequently prevented from earning the sum of 1,680,000 naira as participant. The claimant was removed as member and chairman of the said board by the defendants and denied the claimant from earning the 22,830,000 as earned salaries and allowances out of sheer malice and cruelty. The defense of the defendants. The defendants stated that the purported appointment of the claimant by the first defendant, evidenced by the alleged appointment letter, is unknown to the defendants, in that the defendants do not have any document relating to such appointment in their official records. The claimant did not at any time assume duty or serve as a member or chairman of the third defendant board during the period under reference. as there is no document in the official record of the third defendant and the Office of the Secretary to the Bayelsa State Government showing that he and other persons serve as members of the board of the third defendant. Records, including announcements, letters of appointment, inauguration, and personal details and documentation of all such political appointees are usually kept in the Office of the Secretary to the State Government, and there is no such record for the claimant. The purported appointment of the claimant was supposedly made only about 5 days to the expiration of the temporary tenure of the acting governor of Bayelsa State at that material time. And the alleged appointment later was concocted by the claimant in connivance with the then secretary to the Bayelsa State Government, who is his blood relation, so as to shortchange the first defendant. The defendants are not in any way indebted to the claimant of the alleged sum of 22,830,000 naira or any other sum whatsoever. The purported appointment of the claimant is not regulated by any civil service rules, and the claimant is not entitled to the said sum or any other sum whatsoever from the defendant as salaries and allowances he supposedly earned as member or chairman of the third defendant from 2011 to 2015 or any time at all. The claimant did not write any letter to them requesting any such payment, nor did they promise to pay him or any money or salaries allowance or other entitlements purportedly earned. The claimant, who claims to be a very senior lecturer in the Niger Delta University, could not have suffered any hardship on account of not receiving monies he did not earn from the defendants. The claimant case is not maintainable, having become statute bar by the provision of Section 16 of the Limitation Law, Section 1 of the Public Officers Protection Law, and Bayelsa State, and more specifically Section 43, Sub 1 of the Environmental Sanitation Authority Law, Laws of Bayelsa State 2006. Counsel for the claimant nominated 2 issues for the determination of this suit, to which whether this suit as presently constituted can be defeated by the Limitation Law of Bayelsa State 2006. And secondly, whether the claimant proved that he was appointed as a 4-year tenure chairman or member of the third defendant and was removed abruptly without payment of earned entitled allowances. Counsel for the defendant also nominated 2 issues for the determination of this suit, to which whether, in view of the provision of Section 16 of the Limitation Law of Bayelsa State 2006, Section 1 of the Public Officers Protection Act, Laws of Bayelsa State 2006, and more specifically Section 43, Sub 1 of the Environmental Sanitation Authority Law of Bayelsa State 2006, this action is statute-barred and thus unsustainable. And secondly, whether from the evidence before this court, the claimant has successfully made a case, either legally or equitably against the defendants, to be entitled to all the relief sought. Having painstakingly read the pleadings and evidence led by parties and legal submission of parties in this case, though the issues nominated by parties frontally address the claim of the claimant, I think it is better to recount the issues for determination as follows. 1, whether the claim of the claimant in this suit can be cut up or defeated by the statute of limitations. And secondly, whether the appointment or termination of the employment of the claimant is clothed with statutory flavor under the Environmental Sanitation Authority Laws of Bayelsa State 2006, and whether the claimant has proved his claim to entitle him to the relief sought. So I will skip your legal arguments and I will go to the decision section of this judgment. So court's decision. I have carefully ruminated all the processes filed by both parties and the evidence adduced. On issue 1, which borders on the lifelessness of this suit, I have carefully read the submission of learned counsel for the defendants. The defendant's objection is based on the argument that the claimant's suit is statute-barred, with reliance placed on Section 16 of the Limitation Law of Bayelsa State 2006. The 3-month period provided by both Section 1 of the Public Officers Protection Law of Bayelsa State and Section 43, Sub 1 of the Environmental Sanitation Authority Law of Bayelsa State. By way of recap, may I start by saying that on the authorities of Madukolo against Nkendele and the decision in the case of Attorney General of the Federation against Guardian Newspaper Limited, the competence of a court in the exercise of its jurisdiction is determined if A, is properly constituted with respect to the number and qualification of its membership. B, the subject matter of the action is within the jurisdiction of the court. C, the action is initiated by due process of law. And D, any other condition to the exercise of jurisdiction has been fulfilled. For a court to be competent to assume jurisdiction on a matter, the outlying condition must be conjunctively fulfilled. And flouting one out of these ingredients for determination of jurisdiction render the suit infertile to activate the jurisdiction of the court. The issue of statute bar that was raised by the defendants in the defense and consequently canvassed by parties in their final written addresses is founded in item D of the ingredients for the determination of jurisdiction. Having carefully gone through the facts of this case, as contained in the statement of facts, the claimant was given an appointment later, dated 9th day of February 2012 by the first defendant, but which was made to take effect from the 9th day of February 2011 via the exhibit CW001, but was not allowed to have access to the third defendant on the 14th day of February 2011 because one day, who purported to be the chairman of the third defendant, at that time connived with one Amatu and brought several talks to the office of the third defendant. Now, given the trends in the labor law jurisprudence, the pertinent question to ask is whether this suit is caught up by the provision of Section 16 of the Limitation Law Bayelsa State 2006, the 3 months period as provided by both in Section 1 of the Public Officers Protection Law of Bayelsa State and Section 43 sub 1 of the Environmental Sanitation Authority Law of Bayelsa State. The National Industrial Court has very consistent and plethora of cases, which I mentioned all the cases here. If I give you the judgment, you'll see the arguments I conversed on the issue of statute of limitation. Okay. Yes, and I deliver this even when I was in Bayelsa. So I'll skip that argument. If you receive the copy of the judgment, you will see all the arguments I converse.
As a copy, please.
As a copy.
So finally, I said, on the strength of all the authorities I cited before, therefore, I find and hold that the claimant's case is not statute barred. The claim for the payment of his entitlement from the defendants means that each failure to pay same by the defendants yield to a fresh cause of action, which brings the claimant's case within the continued damage or injury exception of the limitation law. Therefore, issue 1 is resolved in favor of the claimant, and I so hold.
As a court, please.
Flowing from the foregoing, the provision of Section 16 of the Limitation Law of Bayelsa State and Section 1 of the Public Officers Protection Law, Section 43 sub 1 of the Environmental Sanitation Authority Law of Bayelsa State, which provides for the time frame to bring an action against public officers, do not apply to the claim of the claimant, as the claim of the claimants relate to breach of contract of service, and I so hold. On issue 2,
as a court, please.
The claimant claimed to have been appointed as the chairman of the Bayelsa State Environmental Sanitation Authority Board in 2011 by the first defendant, with an effective date of February 9, 2011, see Exhibit CW001. After working with the board until 2012, the claimant position was dissolved by the new government under Honorable Siraki Dixon without justification. The claimant alleges that they were removed without receiving any salary or allowance as chairman and members of the third defendant. The claimant as chairman is entitled to a monthly salary of $427,350 and an allowance of $192,378 to overall monthly earning of $619,757 from 2011 to 2015. Additionally, the claimant claims entitlement to severance and hotel transport allowances totaling $22,870,213 for a 4-year tenure. While the defendants denied appointing the claimant, the defendant stated that the purported appointment of the claimant by the first defendant, evidenced by the alleged appointment letter, is unknown to the defendant, in that the defendants do not have any document relating to such appointment in their official records. The claimant did not at any time assume duty and or serve as a member or chairman of the third defendant's board during the period under reference, as there is no document in the official records of the third defendant and the office of the Secretary to the State Government of Bayelsa State, showing that he and other persons serve as members of the board of the third defendant. The facts of the claimant's case are somewhat complex. Let me use the word complex, which require meticulous consideration by this court. For a proper appreciation of the fact of the claimant, the following questions beg for answers. Question 1. Was the claimant appointed as chairman of the third defendant by the first defendant, and when was the claimant appointed? Secondly, the claimant said the claimant's position was dissolved by the new government under Honorable Sirike Dixon without justification. The question is, when was the dissolution of the position of the claimant? I will hand these two issues contemporaneously. The claimant tendered XBCW 001 to prove that the claimant was appointed as executive chairman of the third defendant. XBCW 001 was dated 9th February 2012, and the appointment of the claimant as executive chairman of the third defendant was to take effect on the 9th day of February 2011. The discrepancy between the two dates on XBCW 001 calls for a great caution. Though the claimant explained under cross-examination that February 2012, which is the date XBCW 002 was written, was a mistake. The defendants had corrected the error and that his appointment is to take effect February 2011. The claimant pleaded and led evidence to state that the first defendant inaugurated the claimant as chairman together with other members of the board of the third defendant for a term of 4 years, following which the claimant worked with other members of the board until the emergence of new government under the leadership of Honorable Sirike Dixon in 2012. And the said Honorable Sirike Dixon-led government dissolved the board without any justifiable cause. The claimant asserts that the claimant was appointed as executive chairman of the third defendant and worked with other members of the board until the emergence of the new government. However, the claimant CW1 stated under cross-examination as follows, and I quote, "When I was appointed, I went to assume duty. There was one Dede who purported to be the chairman of the Bayelsa State Environmental Board at that time, and he connived with one Ahmad and brought several talks to the premises of the office and prevented me from having access to the office located very close to the government house. I went to report to the office on that day. That Dixon was governor on 14th day of February 2012. It is true that I did not resume office before my subsequent removal when the boards were dissolved. I was given the appointment letter on 12th day of February 2012, unquote. Now, if the appointment of the claimant as the executive chairman of the third took effect on 9th day of February 2011, pursuant to XBCW 001, why did the claimant get to be given his appointment letter XBCW 001 on the 12th day of February 2012? The reasonable conclusion here is that XBCW 001, which the claimant claimed was erroneously dated the 9th day of February 2012, instead of 9th February 2012, is a figment of imagination of the claimant. The claimant wanted to lure the court to believe that he was appointed in February 2011. Worse still, the claimant attempted to assume office on 14th day of February 2012, while his purported appointment was terminated on 19th day of February 2012 via the annexure to XBCW 004. The claimant was appointed in February 2012, and his appointment was also terminated in February 2012 without working or assuming office as the executive chairman of the third defendant. The testimonies of the claimant under cross-examination, under examination in chief and cross-examination are not aligned and tallied as River Niger and River Benue meet at the confluence near Lokoja. The answers of the claimant to the cross-examination questions unravel the truth of the case covered by the smoke screen set up by the claimant. In BGL PLC against First Bank Nigeria PLC, reported in 2024, 8 NWLR Part 1942 at page 181, the Court of Appeal held, and I quote, There is no gainsaying the fact that in our adversarial system of adjudication, the object of cross-examination is to test the credibility of an opponent's case. It is meant to puncture and discredit the evidence in chief of a witness. It has the potential to perforate an opponent's case and enhance that of the cross-examiner. It is used to test the veracity of a witness. It is the yardstick with which to measure the truth in the evidence in chief of a witness. It affords the judex the sufficient opportunity to watch and assess the credibility and reliability of a witness by watching his demeanor in the witness box. Unquote. From the totality of evidence before me, I have no hesitation whatever in concluding that there is a connivance and even administrative dishonesty somewhere which gave birth to Exhibit CW001. The purported letter of appointment of the claimant as the executive chairman of the third defendant and the purported dissolution of the board of the third defendant bear a letter issued on the 9th day of February 2012 attached to Exhibit CW004, and I so hold. With due respect to the claimant, who is well read to have reached a professorial cadre in academic, did not notice the discrepancy in Exhibit CW001 and the purported dissolution of the board of the third defendant via a letter issued on the 9th day of February 2012 attached to Exhibit CW004. The claimant stated in his evidence in chief that Honorable Siraki Dixon-led administration dissolved the board without any justifiable cause. While under cross-examination, the claimant stated that Governor Dixon was sworn in as governor of Bayelsa State on 14th February 2022. Surprisingly, it is Right Honorable Nesto K. Binabo, the then acting governor of Bayelsa State, who approved the purported appointment of the claimant as the executive chairman of the third defendant. Is the one who also dissolved the purported board of the third defendant headed by the claimant. Little wonder, the defendants claim that they have no record of the claimant's appointment by the first defendant, as no document exists in their official records or in the office of the secretary to the government of Bayelsa State. The claimant did not serve as a member or chairman of the third defendant's board. And all records of political appointees are typically maintained by the secretary to the state government. The claimant alleged appointment occurred just days before the acting governor's temporary tenure ended, and it is asserted that the appointment letter was fabricated in collusion with the then SSG, who is related to the claimant. Exhibit DW002 reveals that the claimant was not in the scheme of the management of the third defendant at the time the claimant purported to have been appointed as the chairman of the third defendant. Noting that Honorable Regina Dede, the chairman of the third defendant at the time claimant claimed to have been appointed as a chairman. See Exhibit DW002 and evidence of the claimant under cross-examination. For the sake of clarity, Exhibit DW002 reads, and I quote, Permanent Secretary, General Services Bureau, Office of the Secretary to the State Government, Yenegoa, Bayelsa State. Request for further information. Contrary to the claim of the letter of the above subject matter, dated 27 April 2022, I am directed to state the following: that verifiable and available records with the Sanitation Authority does not have any Dr. Jesper F. Abon as chairman of Sanitation Authority at any time before or after February 2012. That Honorable Regina Dede was chairman from July 3rd, 2007 to February 16, 2012. That Comrade Beore, who was the secretary to the Sanitation Authority, acted briefly at the expiration of Honorable Regina Dede's tenure from February 16, 2012 to March 28, 2012. That Honorable Ebi Famoy took over from Comrade Beore as chairman of the Sanitation Authority on the 28th March 2012 till 8th January 2015, when he was relieved of his appointment. This is for your information and necessary action, please. Unquote. As earlier noted, there is connivance and administrative dishonesty in the purported appointment of the claimant and subsequent dissolution of the purported board, which does not exist ab initio. Though Exhibit CW001 and the letter issued on the 9th of February 2012, which purports to have dissolved the purported board of the third defendant headed by the claimant, attached to Exhibit CW004, are public documents which ought to have been presumed regular pursuant to Section 168 of the Evidence Act 2011. However, Section 143 of the Evidence Act 2011 provides, and I quote, Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved, unless and until it is disproved, or may call for proof of it. Sub 2 provides, whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved until unless and until it is disproved. Subsection 3 provides, when one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the one fact, regard the other as proof, and shall not allow evidence to be given for the purpose of disproving it. Unquote. The presumption of the regularity of the act of public officer under Section 168 of the Evidence Act can be rebutted under Section 145 of the Evidence Act 2011. XBCW 001 and the letter issued on the 9th of February 2012, which purports to have dissolved the purported board of the third defendant, headed by the claimant attached to XBCW 004, are products of connivance and administrative dishonesty. The contents of this document make me believe that DW1, where he stated that the purported appointment of the claimant was supposedly made only about 5 days to the expiration of the temporary tenure of the active governor at the material time, and that the allegement letter was concocted by the Secretary to the State Government, who is a blood relation to Chechen, the first defendant. The claimant, though he could sway the court, thought he could sway the court by presenting XBCW 001 and the letter issued on the 9th day of February 2012, which purports to have dissolved the purported board of the third defendant headed by the claimant, attached to XBCW 004. The claimant is not entitled to. The blindfolded symbol of justice means Judex knows nobody in the matter of justice, no matter whose ox is born. This does not mean that the Judex lacks ability to read and analyze the facts presented before it. Assuming my evaluation of the gamut of evidence before me is wronged, it is crystal clear before this court that the claimant was appointed in February 2012, and his appointment was also terminated in February 2012 without working or assuming office of the executive chairman of the third defendant, because the claimant attempted to assume office of the third defendant on the 14th day of February 2012 after his appointment had terminated. There are 3 categories of employment: the pure master-servant relationship, and we have servants who hold their office at the pleasure of their employer, and we have employment with statutory pleasure. In the master-servant relationship, the master has unimpeded right to terminate the employment. However, he must comply with the procedure stipulated in the contract. While in the contract with statutory labor, the employment is protected by the statute. And in the event of termination, employment with statutory labor, strict adherence must be had to the statute. See Longi against First Bank Nigeria and Oripisha against Nigerian Gas Company. Section 5 of the Environmental Sanitation Authority law provides, and I quote, a member of the board shall, unless his appointment is sooner terminated by the governor, or he otherwise ceases to be a member, hold office for such period as the governor may specify in his instrument of appointment. Notwithstanding anything contained in this instrument of appointment, a member of the board may resign his office as a member by notice under his hand, addressed to the governor, and from the date specified in the notice, or if no date is specified, from the date of the receipt of the governor of the notice, he shall cease to be a member of the board. And notwithstanding the provision contained in the instrument by which a member of the board is appointed, each of the members shall be appointed to hold office during good behavior and may be removed at any time by the government, unquote. From the wordings of the provision of Section 5 of the Environmental Sanitation Authority law, it is clear that the appointment and termination of membership of the board members of the third defendant are not protected by the Environmental Sanitation Authority law. The board members hold their appointment at the whims and caprices of the governor, who can appoint them in the morning and terminate such appointment at night. Such, the claimant cannot question the termination of his appointment, and I so hold. Sadly, counsel for the claimant, being a master in the temple of minister in the temple of justice, who ought to have advised the claimant on the nothingness of his claim, filed this suit to have. If learned counsel has studied this case properly, I doubt that counsel will have filed this suit. I will not say much, but I will adopt the dictum of the Court of Appeal in the case of Ojo against Phillips, where the Court of Appeal won, and I quote, one of the elementary lessons which a new week was usually given upon his being sponsored to the enroll at the old Supreme Court was that when a case is thoroughly barred and unsustainable, junior counsel who is briefed to handle the case should study the case very meticulously. And after he has satisfied himself that the case lacks merit, counsel should be bold to advise his client that the case lacks any merit and should not be pursued. If the client insists on pursuing the case, counsel should in his own honor decline to handle the case. It is no credit to any counsel to take a brief, knowing fully well that there is not a slim chance of success to blindly prosecute the case. A case is never prosecuted just for fees due. Counsel must have confidence in the success of the case before obtaining the brief. Perhaps this learned counsel had studied the case very thoroughly, having regard to the pleadings and evidence. It may be that you will not have convinced the appellant that the foundation of the case was rather weak from the beginning to the end. Unquote. On the whole, issue 2 is resolved in favor of the defendants. This suit is bereft of merit and it is accordingly dismissed. And I award a sum of 100,000 naira against the claimant in favor of the defendants. Judgment is here accordingly.
Well, we are very grateful for the well-considered judgment, the time taken, and the erudite presentation. We are most grateful, my Lord.
Thank you. All right.
Mr. Austin.